Question 1. In a high-stakes environment where multiple challenges during a constitutional law case, the state legislature passes a law that restricts certain types of speech based on their content, arguing that this law is necessary to protect public safety. A group of individuals challenges the law, arguing that it violates the First Amendment. The law specifically targets hate speech, which the state argues is harmful to public order and which of the following is the most likely outcome of the legal challenge? A. The law will be upheld because the state has a compelling interest in maintaining public order and safety. B. The law will be struck down because content-based restrictions on speech are subject to strict scrutiny and cannot be justified by the state interest. C. The law will be upheld because the speech in question is considered unprotected under the First Amendment. D. The law will be struck down because hate speech does not fall under the category of speech that can be regulated. Answer. B. The law will be struck down because content-based restrictions on speech are subject to strict scrutiny and cannot be justified by the state's interest. Explanation. Under the First Amendment, speech is generally protected unless it falls within certain unprotected categories, e.g. obscenity, defamation, fighting words, incitement. The Supreme Court has consistently held that content-based restrictions on speech are subject to scrutiny, meaning the state must show that the law serves compelling governmental interest and is narrowly tailored to achieve that interest. The law in question targets hate speech, but hate speech is protected under the First Amendment unless it incites violence or causes immediate harm. The state's interest in public safety does not justify blanket restriction on speech. Therefore, the law would likely be struck down because it violates the First Amendment principle of free speech. Question 2. During a comprehensive review of a process that needs improvement, a federal law grants Congress the authority to regulate interstate commerce, but a state enacts a law that severely restricts the sale of goods crossing state lines, arguing that it is necessary to protect local industries. A business challenges the law, arguing that it violates the Commerce Clause. Which of the following best describes how the court is likely to resolve dispute? A. The court will uphold the state law because it is within the state's police powers to regulate commerce within its own borders. B. The court will strike down the state law because the Commerce Clause grants Congress the exclusive power to regulate interstate commerce and the state law conflicts with that power. C. The court will strike down the state law under the Dormant Commerce Clause, which prohibits states from enacting laws that unduly interstate commerce. D. The court will uphold the state law because the state has the authority to regulate its local economy even if it affects interstate commerce. Answer. C. The court will strike down the state law under the Dormant Commerce Clause, which prohibits states from enacting laws that unduly burden interstate commerce. Explanation. The Commerce Clause gives Congress the authority to regulate interstate commerce. However, states are prohibited from passing laws that unduly burden interstate commerce, even in areas where they have police powers. This concept is known as the Dormant Commerce Clause, which holds state laws that interfere with interstate trade must not impose an undue burden on commerce between states. The court is likely to strike down the law because it violates the Dormant Commerce Clause, which prevents state laws from obstructing the free flow of goods between states unless there is a compelling local interest that outweighs the burden on interstate commerce. Question 3. While investigating a complicated issue between different, the state enacts a law that prohibits certain types of gun ownership, arguing that it is necessary for public safety. A group of individuals challenges the law, asserting that it violates their Second Amendment right to bear arms. The law, however, only restricts ownership of automatic weapons and high-capacity magazines. Where's the most likely constitutional outcome of this challenge? A. The law is unconstitutional because the Second Amendment guarantees an unrestricted right to bear arms. B. The law is constitutional because the government has the power to regulate the sale of weapons to ensure public safety. C. The law is unconstitutional because the government cannot restrict the ownership of specific types of weapons under the Second Amendment. D. The law is constitutional if the restrictions are deemed to be reasonable and not infringe on the core right to bear arms. Answer. D. The law is constitutional if the restrictions are deemed to be reasonable and not infringe on the core right to bear arms. Explanation. The Second Amendment protects the right of individuals to bear arms, but this right is not unlimited. In District of Columbia v. Heller, 2008, the Supreme Court recognized an individual's right to own firearms, but it also acknowledged that this right is subject to regulation. Reasonable and narrowly tailored to serve public safety interests can be upheld, especially when the restrictions do not infringe upon the core right to possess firearms for self-defense or other lawful purposes. The restriction on automatic weapons and high-capacity magazines would likely be upheld because these types of weapons are often seen as posing a greater threat to public safety, and the law seeks to regulate them in a manner that does not interfere in individuals' fundamental right to own other types of firearms. Question 4. While analyzing the root causes of sequential problems in a state enacts a law imposing restrictions on certain types of political contributions, specifically targeting donations from corporations to political campaigns. The state argues that these limitations are necessary to ensure fairness in elections and prevent undue influence from wealthy entities. A group of political activists challenges the law, arguing that it violates the Amendment right to free speech, specifically the right to make political donations. Which of the following is the most likely outcome of this case? A. A law will be upheld because the government has a compelling interest in preventing corruption and promoting electoral fairness. B. The law will be struck down because the First Amendment protects all political donations, regardless of their source or size. C. The law will be struck down because it disproportionately restricts the speech of individuals compared to corporations. D. The law will be upheld because the government has the authority to regulate campaign donations to maintain the integrity of the political process. Answer A. The law will be upheld because the government has a compelling interest in preventing corruption and promoting electoral fairness. Explanation. In Citizens United v. FEC 2010, the Supreme Court ruled that corporations and unions have the right to make independent political expenditures, as such expenditures constitute protected free speech under the First Amendment. However, limitations on direct contributions to candidates for corporations and restrictions on the total amount any entity can contribute to campaigns are still permissible if they serve a compelling government interest. The court has upheld restrictions on campaign finance where they are aimed at preventing corruption or the appearance of corruption in the political process. Therefore, while corporate spending may be allowed in some contexts, restrictions on direct donations to candidates may be justified as serving the public interest. Question 5. In a case where multiple parties have different objectives, a defendant is convicted of a serious crime, but during the trial, the judge instructs the jury that they may consider the defendant's history of prior convictions as evidence of the defendant's propensity to commit similar crimes. The defendant challenges this instruction, arguing that it violates their Sixth Amendment right to a fair trial and that it improperly prejudices the jury. The most likely constitutional outcome of this case. A. The jury instruction will be upheld because it is within the judge's discretion to allow prior convictions as evidence to demonstrate intent. B. The jury instruction will be struck down because it violates the defendant's right to fair trial under the Sixth Amendment, as it unfairly prejudices the jury. C. The jury instruction will be upheld because the Fifth Amendment grants the prosecution broad discretion in introducing evidence. D. The instruction will be struck down because prior convictions are irrelevant to the case under constitutional law. Answer B. The jury instruction will be struck down because it violates the defendant's right to fair trial under the Sixth Amendment, as it unfairly prejudices the jury. Explanation. Under the Sixth Amendment, defendant is guaranteed the right to fair trial, which includes the right to have the jury consider only relevant admissible evidence. While prior convictions can be admitted in some circumstances, evidence of prior bad acts or convictions is admissible if its sole purpose is to show the defendant's propensity to commit crime. The Federal Rules of Evidence, Rule 404b, prohibits the use of prior crimes to show the defendant has tendency to commit crimes. Therefore, allowing the jury to consider prior convictions in this case would likely be deemed prejudicial and violate the defendant's constitutional right to fair trial. Question 6. In a multi-location scenario where consistency requirements, a federal statute grants broad immunities to state governments in lawsuits, including actions under 42 U.S.C. SS 1983, Civil Rights Lawsuits. State challenges the constitutionality of federal law that allows private citizens to sue state officials in federal court for violations of constitutional rights, arguing that the law violates the 11th Amendment by forcing states to defend lawsuits in federal court. Which of the following best describes how the court is likely to rule on this issue? A. The court will uphold the federal statute because Congress has the authority to abrogate state immunity under the 11th Amendment when it acts pursuant to its powers under Section 5 of the 14th Amendment. B. The court will strike down the federal statute because the 11th Amendment protects states from being sued in federal court by private citizens without the state's consent. C. The court will uphold the federal statute because individuals are entitled to sue state officials in federal court under the Supremacy Clause. D. The court will strike down the statute, but only with respect to state officers and not the state itself. Answer A. The court will uphold the federal statute because Congress has the authority to abrogate state immunity under the 11th Amendment when it acts pursuant to its powers under Section 5 of the 14th Amendment. Explanation. The 11th Amendment generally grants states sovereign immunity, preventing them from being sued in federal court without their consent. However, Congress can abrogate this immunity in certain circumstances, particularly where it acts under its enforcement powers under Section 5 of the 14th Amendment, which allows Congress to pass laws to protect civil rights. The court has held that Section 1983 lawsuits can proceed against state officials in their official capacity, as Congress's authority to protect civil rights overrides state immunity in these contexts. Therefore, the court is likely to uphold the federal statute, recognizing Congress's power to ensure remedies, constitutional violations. Question 7. In a high-stakes environment where multiple challenges, a defendant argues that the Fourth Amendment prohibits police from using a thermal imaging device to detect heat sources emanating from a private home, suspecting illegal activity without a search warrant. The police claim that the use of the device does not constitute a search and that no warrant is needed. Which of the following is the most likely constitutional outcome of this case? A. The use of the thermal imaging device constitutes an unreasonable search under the Fourth Amendment and the evidence obtained should be suppressed. B. The use of the thermal imaging device is permissible under the Fourth Amendment because the device does not physically enter the home. C. The use of the thermal imaging device is permissible because the police only obtained information that was already visible to the public. D. The use of the thermal imaging device is permissible as long as the police had a reasonable suspicion of illegal activity. Answer A. The use of the thermal imaging device constitutes an unreasonable search under the Fourth Amendment and the evidence obtained should be suppressed. Explanation. The Fourth Amendment protects individuals from unreasonable searches and requires that searches be conducted with a warrant or probable cause. In Kelo v. United States, 2001, the Supreme Court ruled that the use of thermal imaging devices to detect heat sources from a private home constitutes a search because it reveals information about the inside of the home that would not be otherwise accessible without physically entering. The court held that the use of technology that is not in general public use to gather information from within a home is an unreasonable search and therefore requires a warrant. Hence, the evidence obtained via the thermal imaging device would likely be suppressed as unconstitutional. Question 8. During a seamless transition where continuity must, a state law provides a special exemption for religious organizations from complying with certain health and safety regulations. A group of employees in a secular business challenges this exemption, arguing that it violates the Establishment Clause of the First Amendment, which prohibits government from establishing a religion. What is the most likely constitutional outcome of this case? A. The exemption is unconstitutional because it favors religious organizations and violates the Establishment Clause. B. The exemption is constitutional because it respects the religious freedom of organizations under the Free Exercise Clause. C. The exemption is constitutional because the government is not directly supporting religion, but only accommodating it. D. The exemption is unconstitutional because the Free Exercise Clause does not protect businesses from regulations. Answer A. The exemption is unconstitutional because it favors religious organizations and violates the Establishment Clause. Explanation. The Establishment Clause prohibits the government from enacting laws that favor one religion over others or promote religious practice. Exemptions that provide special treatment to religious organizations in a manner that creates unequal treatment or shows preference for religion can be viewed as violating the Establishment Clause. In this case, providing special exemptions to religious organizations while denying them to secular businesses could be considered as an improper government preference for religion. The Lemon test from Lemon v. Kutzman requires that government actions must not excessively entangle with religion and must serve a secular purpose. The exemption likely violates this test, making it unconstitutional. Question 9. While examining inconsistencies across various units, a state enacts a law that mandates the collection of DNA samples from individuals arrested for felonies, regardless of whether they are convicted. The law is challenged on the grounds that it violates the Fourth Amendment by constituting an unreasonable search and seizure. Which of the following is the most likely constitutional outcome of this case? A. The law will be upheld because the state has a legitimate interest in solving crimes through DNA identification. B. The law will be struck down because it mandates the collection of DNA samples without consent or probable cause. C. The law will be upheld because DNA collection is no different from fingerprinting, which has long been upheld as constitutional. D. The law will be struck down because the Fourth Amendment protects against all form of biometric data collection. Answer: C. The law will be upheld because DNA collection is no different from fingerprinting, which has long been upheld as constitutional. Explanation: the Fourth Amendment prohibits unreasonable searches and seizures, but courts have allowed certain types of biometric data collection, such as fingerprinting, without a warrant or probable cause, reasoning that they serve important law enforcement purposes. In Maryland v. King 2013, the Supreme Court ruled that DNA collection from individuals arrested for felonies is constitutional because it is similar to fingerprinting and serves an important identification purpose that helps in criminal investigations. The court balanced the minimal intrusion of taking DNA with the significant government interest in identifying individuals and solving crimes. Therefore, DNA collection from felony arrestees was deemed a reasonable search under the Fourth Amendment. The court determined that the intrusiveness of collecting DNA is minimal compared to the benefit it provides in solving crimes and ensuring public safety. As a result, the law is likely to be upheld as constitutional. Question 10. In a case where conflict arises between legal standards, a company manufactures and sells a medical device that has been approved by the Food and Drug Administration (FDA). After it enters the market, users of the device experience adverse reactions, and a class action lawsuit is filed claiming that the company failed to properly warn users about potential risks. The company argues that it cannot be held liable because it complied with the FDA's approval process, which includes labeling requirements. What is the most likely legal defense available to the company in this case? A. The company can assert a FDA preemption defense, arguing that compliance with FDA regulations preempts state law claims. B. The company can assert the informed consent defense, claiming that users were adequately warned about the risks of the device. C. The company can argue that its device was misused by the plaintiffs, making it not liable for any injuries. D. The company can argue that the device is not defective and that the adverse reactions were unrelated to the product's design or labeling. Answer A. The company can assert FDA preemption defense, arguing that compliance with FDA regulations preempts state law claims. Explanation: under the doctrine of FDA preemption, if a medical device is approved by the FDA, the company may be able to assert that state law claims related to the device's labeling or safety are preempted by federal law. In Medtronic v. Lower 1996 and Regal v. Medtronic Inc. 2008, Supreme Court held that when a medical device is subject to rigorous FDA approval and regulatory standards, claims based on state law cannot proceed if they conflict with the federal regulatory scheme. This includes claims for product defects or inadequate warnings when the product complies with FDA standards. Therefore, the FDA preemption defense is a strong argument for the company in this scenario. Question 11. In a dispute that involves multiple competing interests, a state passes a law that requires all employers to provide paid sick leave to their employees. An employer challenges the law, arguing that it violates the Commerce Clause of the U.S. Constitution, claiming that the law imposes an undue burden on businesses operating across state lines and interferes with interstate commerce. Which of the following is the most likely outcome of this case? A. The law will be upheld because it is a valid exercise of the state's police powers to protect workers. B. The law will be struck down because it creates an unreasonable burden on businesses and interferes with interstate commerce. C. The law will be upheld because it is necessary to ensure fair wages and workplace conditions. D. The law will be struck down because the federal government has exclusive authority over labor relations. Answer B. The law will be struck down because it creates an unreasonable burden on businesses and interferes with interstate commerce. The explanation: under the Commerce Clause of the U.S. Constitution, Congress has the authority to regulate interstate commerce, and states cannot pass laws that unduly burden or interfere with this commerce. In cases involving state labor laws that affect businesses operating across state lines, the courts often balance the state's interest in regulating labor conditions with the potential burden on interstate commerce. If the law creates significant burden on businesses engaging in interstate commerce, it may be struck down as unconstitutional. In this case, the court would likely strike down the law if it determines that it places an undue burden on businesses conducting operations across state borders. Question 12. In a scenario where procedural fairness is questioned, a defendant is charged with a crime and the court allows the prosecution to introduce evidence of the defendant's prior criminal convictions to demonstrate the defendant's intent and character. The defense argues that the introduction of such evidence violates the defendant's right to due process under the 14th Amendment and will unfairly prejudice the jury. What is the most likely outcome? In this case, the court will allow the prior convictions to be introduced as long as they are relevant to the crime charged. B. The court will exclude the prior convictions as they are too prejudicial and violate the defendant's right to fair trial. C. The court will allow the prior convictions if they show the defendant has a pattern of criminal behavior. D. The court will allow the prior convictions, but only if the defendant is convicted of the current crime. Answer. B. The court will exclude the prior convictions as they are too prejudicial and violate the defendant's right to a fair trial. Explanation. Under the 14th Amendment, a defendant is guaranteed the right to due process and a fair trial. The introduction of prior criminal convictions is generally prohibited unless it is directly relevant to an element of the current crime, such as to establish a pattern of behavior or intent. However, the Federal Evidence Rule 404b limit the use of prior convictions in criminal trials to prevent them from being used solely to show the defendant's character. The court is likely to find that the prior convictions would be unduly prejudicial and strike them from evidence to ensure the defendant receives a fair trial. Question 13. In a high-pressure scenario involving a clash of statutory interpretations, a defendant is convicted of a federal crime involving drug trafficking. The defendant argues that the sentencing guidelines used to impose their sentence are unconstitutional because they result in excessively harsh sentences for non-violent drug offenders, violating the 8th Amendment's prohibition against cruel and unusual punishment. What is the most likely outcome? A. The court will uphold the sentence as it is, within the prescribed statutory range for the crime. B. The court will strike down the sentence, finding that it violates the 8th Amendment because it is disproportionate to the offense. C. The court will reduce the sentence, but only if it finds that the defendant was a low-level participant in the drug trafficking scheme. D. The court will uphold the sentence as it is based on federal law and complies with guidelines. Answer A. The court will uphold the sentence as it is, within the prescribed statutory range for the crime. Explanation. Under the 8th Amendment, cruel and unusual punishment is prohibited, but the Supreme Court has generally held that mandatory sentencing guidelines established by Congress are constitutional as long as they do not result in excessive sentences that are disproportionate to the offense. In Harmelin v. Michigan, 1991, held a life sentence for a defendant convicted of possessing a large quantity of drugs, ruling that long sentences for serious crimes are not automatically considered cruel and unusual. While some sentences may be challenged for being disproportionate, the court typically defers to the legislative intent behind sentencing guidelines, particularly for drug-related crimes. Question 14. In a situation involving claims of discrimination, a university enacts a policy requiring all faculty members to attend diversity training seminars as part of their annual professional development. A faculty member challenges the policy, arguing that it violates their First Amendment right to free speech by compelling them to express support for diversity initiatives that they do not agree with. What is the most likely outcome of this challenge? A. The court will uphold the university's policy as it is, within the institution's right to implement training programs for its employees. B. The court will strike down the policy, finding that it compels faculty members to support specific political or ideological position. C. The court will allow the policy to stand, but require the university to provide alternative options for faculty members who disagree with the training. D. The court will the policy violates the Equal Protection Clause of the 14th Amendment because it discriminates against certain faculty members. Answer A. The court will uphold the university's policy as it is, within the institution's rights to implement training programs for its employees. Explanation. While the First Amendment protects free speech, public institutions like universities have broad authority to regulate the conduct of their employees, especially when the policy furthers educational or professional goals. In Pickering v. Board of Education, 1968. The Supreme Court established that public employees do not have the same level of free speech protection in their roles as private citizens. The court would likely uphold the diversity training policy as legitimate function of the university, provided it is not overly coercive and serves an educational or organizational purpose. Question 15. In a case where state and federal laws conflict, a state passes a law that legalizes the recreational use of marijuana, despite federal law classifying it as a Schedule I controlled substance under the Controlled Substances Act. A federal agency challenges the state law, arguing that it conflicts with federal policy and must be invalidated. What is the most likely resolution of this conflict? A. The state law will be upheld as states have the power to regulate the use of substances within their borders. B. The federal law will be upheld as it has national jurisdiction and supersedes state laws in matters of drug regulation. C. The conflict will be resolved by a compromise that allows states to regulate marijuana but limits its use to medical purposes only. D. The case will be decided based on the Commerce Clause, whether marijuana use in one state has a significant impact on interstate commerce. Answer. B. The federal law will be upheld as it has national jurisdiction and supersedes state laws in matters of drug regulation. Explanation. While states have the power to regulate certain activities within their own borders, federal law generally prevails in matters of interstate commerce and national security. The supremacy clause of the U.S. Constitution dictates that when there is a conflict between state and federal law takes precedence. Although marijuana use is legalized in several states, the federal government has maintained its regulation of marijuana as a Schedule I controlled substance preempts state laws that permit its use. The case would likely be decided in favor of federal authority unless Congress changes the law or grants exceptions. Question 16. In a case involving the balance between privacy and security, a law enforcement agency uses a stingray device to track the location of a suspect's cell phone without warrant. The defendant argues that the use of the device violated their Fourth Amendment rights against unreasonable searches and seizures. What is the most likely outcome of this case? A. The court would uphold the use of the device, ruling that it is an acceptable tool for law enforcement to track criminal suspects. B. The court will rule that the use of the stingray device violated the Fourth Amendment because it involved search without warrant. C. The court will rule that the device's use was not search because it only detected signals from the cell phone, not the content of communications. D. The court will allow the use of the device, require law enforcement to obtain warrant for future uses. Answer. B. The court will rule that the use of the stingray device violated the Fourth Amendment because it involved a search without a warrant. Explanation. The use of a stingray device, which mimics a cell phone tower and intercepts signals from nearby phones, is generally considered an invasive search under the Fourth Amendment. The Supreme Court in Carpenter v. United States 2018 ruled that the government's acquisition of historical cell phone data constitutes search and warrant is required. Similarly, tracking suspects' location in real time using such device likely requires warrant, as it is significant intrusion on the defendant's privacy. The court is likely to rule that the stingray device violated the Fourth Amendment because it was used without warrant. Question 17. In a case involving corporate liability for environmental harm, a company discharges toxic chemicals into a river causing environmental damage. The company claims that the Clean Water Act only imposes liability for discharges that occurred directly into navigable waters and that the chemicals were released into a tributary before reaching a larger body of water. What is the most likely legal outcome of this case? A. The company will be found liable as the discharge of toxic chemicals into a tributary is still covered by the Clean Water Act. B. The company will not be held liable as the discharge occurred into a tributary rather than directly into a navigable waterway. C. The company will be found liable for violating state environmental regulations, but not the federal Clean Water Act. D. The company will be allowed to avoid liability. It can show that the discharge did not significantly harm the environment. Answer A. The company will be found liable as the discharge of toxic chemicals into a tributary is still covered by the Clean Water Act. Explanation. The Clean Water Act is broadly interpreted to regulate discharges into all waters of the United States, including tributaries, wetlands, and other connected bodies of water. The Act prohibits the discharge of pollutants into navigable waters without a permit, and courts consistently held that tributaries and other connected waterways fall under the Act's jurisdiction. Therefore, the company will likely be found liable for its actions, even if the discharge occurred into tributary, as long as it flows into larger navigable waterway. Question 18. In a case involving trademark infringement, a company releases a new product that features a logo strikingly similar to an existing, well-known brand's trademark. The original brand sues for trademark infringement, arguing that consumers will be confused and believe the two products are related. What is the most likely outcome of this case? A. The court will rule in favor of the original brand, finding that the similarity of the logos is likely to cause consumer confusion. B. The court will rule in favor of the defendant, finding that the logo is not confusingly similar to the original brand's trademark. C. The court will order the defendant to pay damages but allow them to continue using the logo. D. The court will dismiss the case, ruling that trademarks do not protect logos in entirety. Answer A. The court will rule in favor of the original brand, finding that the similarity of the logos is likely to cause consumer confusion. Explanation. In a trademark infringement case, the court evaluates the likelihood of consumer confusion as a primary factor. If the logo is similar enough to the existing trademark to cause consumers to believe that the products are related, the court will likely rule in favor of the original brand. The LANAM protects trademarks from infringement that causes confusion, deception, or mistake among consumers, and courts often focus on the similarity of the marks, the strength of the original mark, and the market conditions. Question 19. In a case involving intellectual property protection, a software company develops a new application that utilizes a unique algorithm. A competitor releases a very similar application that appears to be using the same algorithm, but it does not explicitly copy the company's code. The original company claims that the competitor's application infringes its patent on the algorithm. What is the most likely outcome of this case? A. The court will find in favor of the original company, ruling that the competitor infringed on its patent by using the same algorithm. B. The court will find in favor of the competitor, ruling that the algorithm is not patentable and cannot be protected. C. The court will rule that the competitor infringed the patent only if the original company can prove that the algorithm is proprietary and unique. D. The court will find that the software's code, not algorithm, is the protected intellectual property and dismiss the case. Answer C. The court will rule that the competitor infringed the patent only if the original company can prove that the algorithm is proprietary and unique. Explanation. In a patent infringement case, the company must demonstrate that its algorithm is patentable and that the competitor is using the patented method without authorization. If the algorithm is patented, the company would need to show that the competitor's application performs the same function using this method. If the competitor has made substantial changes, or if the algorithm is not novel enough to be patentable, the case may be dismissed. Therefore, the outcome will depend on the originality and uniqueness of the algorithm in question. Question 20. In a case involving election law and voting rights, a state passes a law requiring all voters to present a government-issued photo ID at the polling station. A group of voters challenges the law, arguing that it disproportionately affects minorities and low-income voters who are less likely to have such IDs, thus violating their right to vote under the 15th Amendment. What is the most likely legal outcome of this case? A. The court will uphold the law, ruling that it is a reasonable measure to prevent voter fraud. B. The court will strike down the law, finding that it imposes an undue burden on certain groups of voters. C. The court will modify the law, requiring the state to offer free photo IDs to all voters. D. The court will rule that the law does not violate the 15th Amendment as it is applied to all voters equally. Answer. B. The court will strike down the law, finding that it imposes an undue burden on certain groups of voters. Explanation. While states have the power to regulate elections, the 15th Amendment prohibits discrimination based on race and color, and courts are sensitive to laws that disproportionately affect minority groups. In cases like Shelby County v. Holder 2013 and Crawford v. Marion County Election Board 2008, the Supreme Court has ruled that voter ID laws can be challenged if they disproportionately burden certain groups, such as low-income or minority voters. If the court finds that the law imposes such a burden without sufficient justification, it is likely to strike it down. Question 21. In a case involving the death penalty, a convicted murderer in a state that allows the death penalty claims that his sentence violates his 8th Amendment rights against cruel and unusual punishment because the state uses a lethal injection protocol that has caused botched executions in the past. What is the most likely legal outcome of this case? A. The court will rule that the lethal injection protocol is constitutional as long as it does not cause unnecessary pain and suffering. B. The court will rule that the death penalty is unconstitutional in all circumstances, regardless of the method used. C. The court will order the state to revise its lethal injection protocol to ensure it is more humane. D. The court will rule that the death penalty is constitutional but place a temporary moratorium on its use in this particular state. Answer A. The court will rule that the lethal injection protocol is constitutional as long as it does not cause unnecessary pain and suffering. Explanation. The Eighth Amendment prohibits cruel and unusual punishment, and the Supreme Court has held that the death penalty itself is not inherently unconstitutional. However, it has also emphasized that execution methods must avoid causing unnecessary pain or suffering. In Bays v. Reese, 2000, the court ruled that lethal injection is not unconstitutional unless it presents a substantial risk of severe pain. Therefore, unless the method is proven to be excessively cruel, the court is likely to uphold the current protocol but may require improvements. Question 22. In a case involving a First Amendment issue, a city ordinance bans all public demonstrations, including protests on a popular public sidewalk located near a major university campus. A group of activists sues, arguing that the ordinance violates their First Amendment rights to freedom of speech and assembly. What is the most likely outcome of this case? A. The court will uphold the ordinance, ruling that it is a necessary public safety measure. B. The court will strike down the ordinance, finding that it violates the right to free speech and assembly in public spaces. C. The court will modify the ordinance to allow protests, but require them to be scheduled in advance and supervised by police. D. The court will rule that the ordinance only applies to certain forms of protest, but allows demonstrations on sidewalks. Answer B. The court will strike down the ordinance, finding that it violates the right to free speech and assembly in public spaces. Explanation. The First Amendment protects the right to free speech and peaceful assembly, particularly in public spaces. In U.S. v. Grace, 1983, the Supreme Court ruled that public sidewalks are traditional public forums where free expression is strongly protected, unless the government can prove that a specific time, place, or manner restriction is narrowly tailored to serve a compelling interest, such as public safety. The court is likely to strike down the ordinance as unconstitutional. Question 23. In a case involving an individual's right to privacy, a company collects extensive personal data from its users, including browsing history and location information, without explicit consent. The company claims that it is allowed to collect this data under its terms of service agreement, which users accepted when they signed up for the platform. What is the most likely legal outcome of this case? A. The company will be allowed to continue collecting data without additional consent as long as it is disclosed in the terms of service. B. The court will rule that the company violated the user's right to privacy by collecting personal data without their informed consent. C. The court will allow the company to collect data but require it to give users the option to opt out of specific types of data collection. D. The court will rule that the Companies Act violate the Fourth Amendment as the data collection constitutes an unreasonable search. Answer. B. The court will rule that the company violated the user's right to privacy by collecting personal data without their informed consent. Explanation. Under privacy laws and regulations, particularly those in place in the European GDPR and the California Consumer Privacy Act (CPA), companies must obtain informed consent to collect personal data. Courts are increasingly requiring companies to provide clear information on users' data is being collected, processed, and shared. In the U.S., informed consent is key, and data collection without explicit consent, especially when users are not clearly informed, could be deemed an infringement on privacy rights. Question 24. In a case involving intellectual property rights, a tech company creates a patented algorithm that allows users to efficiently search through large data sets. A competitor releases a very similar software, claiming that their algorithm uses a different method for processing the data and is not an infringement. What is the most likely outcome of this case? A. The court will rule that the competitor infringed on the patent if the algorithm performs the same function in a substantially similar way. B. The court will rule in favor of the competitor, finding that the algorithm is not patentable and therefore not infringed. C. The court will rule that the algorithm is not eligible for patent protection as it is an abstract idea. D. The court will allow both companies to continue operating and suggest a agreement. Answer A. The court will rule that the competitor infringed on the patent if the algorithm performs the same function in a substantially similar way. Explanation. Patent infringement claims generally require the patent holder to show that the competitor's product performs the same function in substantially the same way, or that the method is obvious or lacking in novelty. In cases where two algorithms achieve similar results using similar methods, the court will look at the competitor's work is substantially equivalent to the patented method. If so, the court is likely to rule in favor of the plaintiff for patent infringement. Question 25. In a case involving discrimination in employment, an employee sues their employer, alleging discrimination on the basis of race, claiming that they were passed over for a promotion in favor of a less qualified individual who is of a different race. What is the most likely outcome of this case? A. The court will rule in favor of the employee, finding that the employer's decision was motivated by discriminatory intent. B. The court will rule in favor of the employer, finding that the decision was based on non-discriminatory factors. C. The court will require the employer to provide compensation to the employee, but will not require any change in the promotion decision. D. The court will dismiss the case if the employer can demonstrate that the promotion, based on legitimate, non-discriminatory reasons. Answer D. The court will dismiss the case if the employer can demonstrate that the promotion was based on legitimate, non-discriminatory reasons. Explanation. Under Title Roman of the Civil Rights Act of 1964, employers are prohibited from discriminating based on race, color, religion, sex, or national origin. However, an employer can defend its decision by showing that the promotion was based on legitimate, non-discriminatory, such as the employee's qualifications or performance. If the employer can show that race was not a factor, the court is likely to rule in favor of the employer. Question 26. In a case involving dispute resolution in contract, a contract between two companies includes a clause requiring disputes to be resolved through binding arbitration. One party argues that the arbitration clause is unenforceable because it was included in the fine print of the agreement and was not adequately disclosed. What is the most likely outcome of this case? A. The court will enforce the arbitration clause as long as both parties agree to it by signing the contract. B. The court will rule that the arbitration clause is unenforceable because it was buried in the fine print and not sufficiently disclosed. C. The court will require the parties to resolve the dispute in mediation rather than arbitration. D. The court will invalidate the entire contract because of the unfairness of the arbitration clause. Answer B. The court will rule that the arbitration clause is unenforceable because it was buried in the fine print and not sufficiently disclosed. Explanation. While arbitration clauses are generally enforceable, courts will not enforce them if they are deemed unconscionable or unfair. If a party can prove that the arbitration clause was hidden in the fine print or was not adequately disclosed, the court may find that it was not agreed to voluntarily, or in such cases, the clause may be considered unenforceable under contract law principles. Question 27. In a case involving free speech on college campuses, a university enacts a policy restricting speech that it deems offensive or hateful. A student group challenges the policy, claiming that it infringes on their First Amendment rights to free speech. What is the most likely outcome of this case? A. The court will uphold the policy, ruling that the university has a legitimate interest in maintaining a safe and respectful environment. B. The court will strike down the policy, finding that it unconstitutionally limits free speech on campus. C. The court will modify the policy to allow speech that does not incite violence or disrupt the learning environment. D. The court will rule that the policy is constitutional but apply a strict standard to evaluate its validity. Answer. B. The court will strike down the policy, finding that it unconstitutionally limits free speech on campus. Explanation. Public universities are required to adhere to the First Amendment and cannot impose overly broad restrictions on speech, particularly when it pertains to ideas or expressions that may be offensive but not threatening or violent. In Healy v. James, 1972, the Supreme Court ruled that students do not lose free speech rights simply by attending college. Unless the speech is likely to incite violence or disrupt the academic environment, restrictions on speech will typically be struck down. Question 28. In a case involving constitutional rights and police searches, a police officer stops a vehicle for a routine traffic violation. During the stop, the officer smells marijuana and searches the vehicle without a warrant, finding illegal drugs. What is the most likely legal outcome of this case? A. The evidence will be admissible as the officer had probable cause based on the smell of marijuana. B. The evidence will be inadmissible because the officer did not obtain a warrant before conducting the search. C. The court will allow the search, but only if the officer was able to articulate a specific threat to safety. D. The court will suppress the evidence and find the search unconstitutional. Answer A. The evidence will be admissible as the officer had probable cause based on the smell of marijuana. Explanation. Under the Fourth Amendment, police officers may conduct searches without a warrant if they have probable cause to believe that a crime has occurred. In California v. Acevedo, 1991, the court held that an officer can search a vehicle if they have probable cause, such as the smell of marijuana, even without a warrant. Exclusionary rule does not apply in this case because the officer had probable cause to conduct the search. Question 29. In a case involving workplace safety, an employee is injured at work while using equipment that did not have proper safety features. The employee sues their employer for failing to maintain a safe work environment. What is the most likely legal outcome of this case? A. The court will find in favor of the employer, ruling that the injury was the result of the employee's negligence. B. The court will rule in favor of the employee, finding that the employer violated workplace safety regulations. C. The court will require the employer to provide workers compensation benefits but not be held liable for the injury. D. The court will dismiss the case as workplace safety violations are typically handled by regulatory agencies. Answer B. The court will rule in favor of the employee, finding that the employer violated workplace safety regulations. Explanation. Under Occupational Safety and Health Administration (OSHA) regulations, employers are required to maintain a safe workplace for employees and ensure that equipment is safe to use. If an employer fails to provide necessary safety measures or equipment, the court is likely to rule in favor of the employee for work safety violations. Question 30. In a case involving consumer protection, a company sells a product that claims to cure chronic ailments, but there is no scientific evidence to support the claims. A consumer files a lawsuit against the company for deceptive advertising. What is the most likely legal outcome of this case? A. The court will rule in favor of the company as there is no law preventing the sale of products without scientific proof. B. The court will rule in favor of the consumer, finding that the company's advertising constitutes fraudulent misrepresentation. C. The court will require the company to provide a refund but not impose any other penalties. D. The court will allow the product to remain on the market but will require the company to include a disclaimer regarding the lack of scientific evidence. Answer B. The court will rule in favor of the consumer, finding that the company's advertising constitutes fraudulent misrepresentation. Explanation. Under consumer protection laws, including the Federal Trade Commission (FTC) regulations, companies are prohibited from making false or misleading claims about their products. If a company advertises a product as being effective for curing ailments without scientific backing, this constitutes fraudulent misrepresentation. The court is likely to rule in favor of the consumer and may impose penalties or require the company to stop making deceptive claims.